for a building. After he had dug up, invested all the money, and all the time the claimant was watching, then the injunction comes. I was involved with the court cases regarding SGR. There were many injunctions that came stopping construction of the SGR when the contractor was on the ground and the contract was providing that for each day work does not go on, you pay all these workers the stoppage of work penalty clause. So I have a first-hand experience of how injunctions frustrate development. Maybe not all the injunctions, but some unserved injunctions. But that is not to say that the court should not issue injunctions. I'm only saying that perhaps we should go back to the basic principles of if you want an injunction, come early. Not when I'm 70% done with the project. Number two now, there is also that perception that, but maybe before I answer, you could ask me now the first lead of the question about perception of corruption. And how
I think let us run with this. You've identified the areas that judiciary is an hindrance to economic growth or slows economic growth. What, as you're coming in now as a very senior member of judiciary, Godwinning, what are the possible solutions to it so that it can go out corruption?
Thank you. One of the possible solutions is this, and I have seen it work in the UK. When you come for an injunction, you are supposed to attach the undertaking on damages. You're supposed to come with an undertaking on damages without being requested by anybody. If you don't bring it together, you won't get an injunction. If the plaintiff, so if you're having these persons who I would call extortionists, who wait for your project to kick off, then they go for an injunction, then if you demand that they are taking that on damages, they won't come. Number two, also in the UK, they insist that if the injunction is going to cause some damage to the project, and it's suspected you cannot pay for that damage, then bring security together with the undertaking. Security regarding damages. That ensures that the only person who comes for an injunction is a person who is really convinced that he will win the case at the end. Yes. So I would suggest that we go for mandatory undertaking on damages and in some cases security before we give the injunctions.
Okay, yes, I think that you will argue with your fellow legal minds. I'm not so on that, but I'm satisfied with the answer. My second thing was on corruption. You see, many stakeholders, many people out there, they say, you see, corruption has become a real menace in this country, and has become very difficult to minimize it or eliminate it. Yes. And the worst part of it is that judiciary has become a player, and they always say it is the weakest link.
Yes.
But some who are on the side of judiciary say that it cannot be a weakest link because it is not in the act itself, because there is no role that it plays before the litigation comes.
Yes.
And therefore, when you look at the weakest link theory, yes, it says that unless you are in the sequence, you can't be blamed. You cannot be the weakest link if you are not in the sequence. Yes. So what is your view as a scholar and as a practitioner? Do you agree that judiciary is the weakest link in corruption, in fighting corruption? Or what is your view generally? There's been no restriction in that fight.
Yes, it's a mixed view. In this sense, me where I come from, we normally say this, that we will build for you a house with the materials you have brought. So if the DPP and the EACC brings a weak case, those are the materials they have brought. There is nothing much that the court can do except to build a case using those weak materials. So that is the first part of it.
Yes.
But also, there is an element in which when the cases come to court, they take too long. That The EFCC says, I've done my work, I've given the file to DPP. DPP says, I've done my work, I've given it to the court. Then the case takes 10 years, 11 years in court. Let me say that for my PhD, I examined exactly that area. It was prosecuting corruption offenses, how we can improve exercise of prosecutorial discretion, how to exercise that prosecution power. And I examined the pattern, the movement of the cases from investigation all the way to the judgment. And even though the Anti-Corruption and Economic Crimes Act says that the case will be heard on a day-to-day basis, we still see cases being adjourned for 7 months, 6 months. So I believe that there is a lot the courts can do to remove that impression, as the weakest link. I'll give an example of what we could do. What we do with election offenses, with the election petitions. Day to day, hearing day to day, in 6 months you have your answer. Maybe you could just do that with corruption cases. Okay. Yes.
My final question comes from, again, when I went through your CV,
yes.
You've done a lot of community service.
Yes.
You've done pro bono work, you are working as a chancellor in this ambassador since.
Yes.
And many other things around giving out your time. Could you explain to us, perhaps, to understand this philosophy of public involvement and a practice of giving your time to community service? What drives you? What's the philosophy behind it?
Maybe it's where I came from. Yes.
What is happening where you come from?
Where I came from, I wore my first shoe when I was in Taran 5.
Yes.
Yes. So when I see poor people who need help, yes, I appreciate where they are and I want to help. That is a philosophy. Yes, that is a philosophy.
Can you link it now to this job that you are being interviewed for? Is there any effect from the same, the thinking,
yes,
the approach?
Yes.
What do you bring in from that framework of
yes. Where we started? Yes. Social transformation through social justice, so that we deal with the ones who are excluded because I was excluded, those ones who are suffering inequalities because I was there, and then protect those ones who are vulnerable because I was. So that's what I would do. The jurisprudence I was playing in that court would be informed by that. Yes.
Thank you, Dr.
Yeah, thank you very much.
Yes.
Now to the next set of questions. And that's by Commissioner Eka.
Thank you, Mr. CJ. I have 3 questions for you, Dr. As you're aware, the Court of Appeal is a court where you have to work with other judges.
Yes.
So, what in the personal skills do you possess that will help you work with your colleagues and still maintain your independence in terms of decision?
So did Professor ask for my personal skills?
Yeah, your interpersonal skills that will help you work with your
Thank
colleagues.
you, Professor.
Yeah.
Number 1, I'm a good listener. I can listen until you ask whether I'm hearing. So I'm a good listener. And I believe that would help in listening to the opinions of the others and considering genuinely before I come to a decision. Number 2, I believe that I am sociable. I'm able to interact freely with people. And I believe that would fit well with collegiality that's required at the Court of Appeal. And I also respect the other people. I also respect my fellow mortals. Professor, yes.
I'll give you a scenario,
Yes.
and then you tell me how you handle it. A federal judge
Yes.
skips sessions.
Yes, yes, Professor.
They're supposed to meet, but they skip.
Yes, Professor.
Therefore, the decisions are not taken, judgment is delayed. How do you deal with that colleagues like that? And on the bench, they're not coming, and therefore it also reflects on that bench. What would you do?
I think the first thing would be to really engage them to see what's really happening. Is there perhaps a personal problem he's going through that perhaps is causing this? But my objective in all that would be to persuade the person to come because we are jointed, to come and perform his duty. If everything else fails, if all the effort fails, perhaps then I will consult the president of the court so that we can come up with a solution on how we can address the problem so that we can maintain so that we can maintain the confidence of the public, yes, in the discharge of the duties.
My other question is, people say that intelligence, as IQ,
Yes.
is less important
Yes.
than emotional intelligence, particularly in the kind of job that you want to do.
Yes.
Number one, do you agree with that statement? And maybe you can start it by telling us what you understand by emotional intelligence, and then you tell us whether you agree that it's more important than IQ, especially for the kind of job you want to do.
Thank you, Professor. I understand emotional intelligence to be the ability of a person to introspect and understand his or her own emotions and see how your own emotions react to situations and to other people, and also to understand the emotions of the other people. Yes, that's my understanding of emotional intelligence, to perceive the emotion. Now, compare now with the what do you call it?
The IQ, the IQ.
With the IQ, compared with the IQ, I believe, Prof, that situations need both. All situations need both, Professor. Yes, need both.
And lastly,
could you demonstrate to the commission that you are that judge who will be able to make hard decisions, sometimes decisions that may go against the grain, as you exercise your independence? You can give us maybe instances where you're about to make hard decisions, and because that is what you believed in.
Yes, when I was a member of the Judicial Commission of Inquiry in Tana River, we were investigating the causes of the violence. And as I said before, much of it had to do with failure to enforce criminal law. So I had a situation, I was put in a situation whereby I had to summon officer commanding stations and examine how they dealt with reports that were made to them. But they were the same person, and in many cases we exposed them as not having done their work of investigating and taking these crimes to court. Now, the trouble was that it was a different situation. There were still the ones who were guarding me, and tomorrow I'm supposed to interrogate them, to cross-examine them. So I had to make a decision. Do I now fear these people? Do I now bend to their pressure and fail to get to the core of the issue that you're not enforcing the law? This is why people have to cut each other. And I had to make a very hard decision at the risk of my own safety, that we have to look at every occurrence book that was in Tana River, the only 3 stations, and expose the failure to prosecute prosecute those offenses relating to destruction of animals and destruction of crops. That was very hard for me, but it paid off. Because, yes.
That's a good example.
Yes.
My colleague, Honorable Judge Majoya, said that you mentored him. What deliberate things do you do to mentor the young lawyers or people below you? One or two? Or the mentoring just comes?
I show them the vision. I show them the vision. I tell them, but I've not told Justice Majanja, but if I meet him, I'll tell him, Judge, you can be a judge and a professor. That's my vision of subject Justice Majanja, yes.
So what do you do? Sorry, just
I talk like donating my time to be availing myself, just availing myself first and foremost, so that we can have those kind of discussions, Professor.
okay. Thank you.
Yes.
Thank you, Sujay.
Thank you, Honorable CJ. Maybe to start off, I just want to apologize. When I greeted you earlier, I referred to you as Mr. NDEGWA. I think I'm still having hangovers from the days we used to practice in university. And I come from a community that is a respected title. So let me address you properly, Dr. WAMUTI NDEGWA. Good morning again.
Thank you, Commissioner.
I'm sorry, I just want to take you briefly back to the question of your writing, I mean, in respect to the bail and bond.
Yes.
Commissioner Machada had questioned you a bit on that. I just want some clarification.
Yes.
It strikes me like you're the kind of person that thinks outside the box, which is a good quality.
Yes.
But it's also important to always remember there has to be a box to think out of. You don't think out of the box and lose a box.
Yes.
Lose the box.
Yes.
So in your writing, you are talking about two schools of thought when it comes to bail and bond. One you're calling the guarantee appearance, and the other the penalty school.
Yes.
You tackle the two schools,
Yes,
and
yes.
if I understood you correctly, in the Kenyan context, in our judicial system, we lean more towards the first school, the guarantee appearance school.
Yes.
That places a lot of emphasis on giving like monetary security to ensure that the person will be compelled to attend, as opposed to the penalty where it's about if you don't attend, these are the consequences.
Yes.
So I was just analyzing those, and I was looking at our social context as Kenyans. Do you think we are, because your writing is like you're suggesting we ought to be moving towards the penalty school of thought. Do you think as a society, in our context, we're actually ready for that move?
Thank you, Commissioner. I think somewhere in between, but really addressing a different point, saying that the overriding objective of the court is to see that this person comes back, to see that he comes back. If he guarantees me and I'm satisfied that he will come back, then the issue of security would not even arise, because security is a punishment for not coming back. But if there is a guarantee that he'll come back, I will not keep him in the cells because he was not able to bring a logbook or a title deed if I'm satisfied that he will come back. Yes. Even if he assures me, like for example now, if I appear in your court charged, I tell you, I'll be in your court tomorrow with this and this matter. That kind of guarantee. If there is an assurance he'll come back, do not place obstacles to the right, to the constitutional right to bail.
In the practical context now, that is it sounds very nice in theory actually,
yes.
But now in the practical context, I'm looking at the Kenyan society as we are.
Yes.
There's nothing to compel me to come to court at all. There's nothing you are holding.
Yes.
I could actually move from Mukuru Ruben and go to Mukuru Njenga and you will never find me. Yes. Do you think that's practical? Do you think that can work in our Kenyan context? What you're suggesting?
Yes, what I'm suggesting, let us remember it's something slightly different. I focus on a title deed or a logbook, the requirement of a title deed and a logbook. And the paper says that the number of Kenyans who own logbooks are less than 4 million because we have less than 4 million cars in Kenya. Okay? And for title deeds, we know there are so many who are landless. So the point I was making is this: if I'm given a board of 100,000, let us not ask for a title deed because that costs millions, or a logbook because it may cost $1 million or $2 million. So I was focusing on especially those two assets. So I should be allowed to say, I have brought the cash. So there's a punishment for me if I don't show up.
Okay.
Yes.
That is what I needed you to clear, because the impression I was getting is like you were proposing we should move to the non-monetary recognizers, and I was wondering if that would really work for us.
Yes.
But if that is what you're supporting, then that's okay.
Thank you, thank you.
Okay, the questions I wanted to ask have majorly been covered by my colleagues, but I just want to look at another aspect of those areas.
Yes.
Basically, the practical aspects.
Yes.
Now, it is said that performance is a tool. Performance management is a tool.
Yes.
So, in your view, is it a tool for the management or is it a tool for the employees?
Both.
For both.
For both, because they both have an interest in delivering the service.
Mm-hmm.
Yes.
What is the interest of the employees, for instance?
The interest of the employee, ordinarily, it will be perform the duties he's tasked with and he gets paid. He delivers the value for the money he's getting.
Would that be the interest of an employee, that I must perform to be paid? Like, for example, let's look at the judiciary scenario.
Yes.
What is my interest in performance management, the performance management system that we have? I'm a clerk in the registry, for instance.
Yes. I would look at, like you commission, I would want to look at that performance management tool as a very important tool for the clerk who wants to rise to the level of executive officer, so that the promotions are not whimsical. He also wants to measure his performance and show, I performed, I hit my targets all the time. So there is a good cause or good evidence when I apply for promotion.
Thank you. You've actually answered the question.
Yes.
So now, how have you applied that concept in your law firm? I've seen in your papers you also have a law firm, isn't it?
Yes.
How have you applied that and what results?
We have applied it because we have we have our own tool that is very, very basic. That requires that a person is able to show that we are complying with the timelines that we have given ourselves. Yes, like for answering correspondence within a day, like for drafting opinions within like maybe 5 days, like for filing pleadings within the times that are required.
So you have that
procedure.
framework in your law firm?
We have that framework, and it works, especially when you are discussing pay rise. Yes.
Thank you. The other thing I wanted to ask you concerns corruption. You discussed that with my colleagues, but like I said earlier, I want us to move to a more practical aspect, steps that you take.
Yes.
One of the sayings out there is that the corruption in the judiciary is more perception than reality. I don't know if you agree with that.
There is some basis for that perception, because even when you look at the annual reports, I think the judiciary makes a report every year. You see the judiciary itself reporting that there were these issues, and this is the way we dealt with them. So there is a perception, but it has some basis. It has a basis. But now that said, I would say that the perception is over-exaggerated because there are many judicial officers who are working diligently and with integrity, just like lawyers. People say lawyers are this, but I'm not. Yes, so I appreciate that. Yes.
Thank you. I think I agree with you about
Yes.
the exaggeration of the perception.
Yes.
Now you are likely to join the Court of Appeal.
Yes.
What practical steps would you take to cure that situation? Because it's a very unfortunate situation that we've really been grappling with.
Yes.
To cure that perception.
Thank you, Commissioner. I think I would want to engage the public and tell them this is reality, this is how we do our work. Yeah. Communication. If there are complaints, I think it would be good to give a channel for giving the complaints and giving a feedback, so that the public gets confidence that what we thought is not. And also transparency. transparency, so that when you look at the decision, you can see that this decision was based on the facts and the law, so that even the person who ends up in jail appreciates that there was evidence, and that's what the law says, that he should go to jail. Transparency and engaging the public. Yes.
Thank you very much. Okay, now maybe we can move on to something else. You are required in the advertisement for the job to submit certain documents. I believe as a lecturer, you are a public servant.
Yes, I like
Do you file wealth declarations periodically as is required?
Yes, I do.
So you are required to submit your last 3. I noticed you only submitted the one at the time of application. Is there a particular reason why?
No, I submitted 3.
Submitted the last
Yes.
3?
Yes, I submitted the last 3.
Okay, then I guess we look at them because the one that was
Submitted
submitted to me showed only 1. Otherwise, I don't have any other questions concerning the documents.
Yes.
Thank you very much for your time.
Thank you.
Thank you, Madam
Thank you.
Leader.
Thank you.
Thank you very much. Unless there is any other issue, on behalf of the commissioners, I want to thank you very much for a very interactive engagement with you. I wish you all the best. We will contact you when we finish the exercise.
Thank you, Chair. Thank you, Chair. Do I have permission to start?
Yes, you have permission.